Yeah, very good afternoon to everyone. We welcome you all in today's webinar being organized by Research Committee of ICAI, the oldest technical committee of the Institute of Chartered Accountants of India, on very timely topic, the importance of legal research methods in commercial and tax advices. Uh, we have with us our learned speaker, Dr. N.S. Nigam sir. We have session chairman, CA R.K. Gode sir. We have our own chairman to the committee, the fifth term council member, CA Anuj Goyal ji, along with the all research committee secretariat and dear viewers. Uh, I welcome all of you on behalf of the research committee. Now I take privilege to introduce the session chairman, CA R.K. Gode ji, very senior chartered accountant by profession and who holds masters in economics and law. And very interesting thing I found about him, he is the convener of one of the oldest CP study circle of Northern India Regional Council of Chartered Accountant, the convener of East and CP Study Circle of NIRC of ICAI. So with his great experience in continuing professional learning, I think as a session chairman, he would be contributing well. So we have the presence of Dr. N.S. Nigam, a very learned speaker, very learned fellow, and he is professor and dean of School of Law, B.M. Munjal University, Gurgaon, the very prominent university, and he is a dean of that law school. Previously, he was visiting professor at NLSIU Bangalore and an associate professor at Ajimji Premji University, Bangalore. He holds a DPhil in law from Oxford University and LLM taxation from New York University School of Law. Professor Nigam also taught commercial law and international tax laws at BPP University, London, United Kingdom. He is also author of a monograph on international taxation from an Indian perspective. He has a number of publications to his credit in national and international journals. We are really very thankful for Dr. Nigam for sparing his valuable time for the session of the day. And now I take privilege to introduce my own chairman, CA Anuj Goyal. CA Anuj Goyal don't require any introduction among the chartered accountant fraternity. He is a member of all the three institutes at the age of 22 years. He is a chartered accountant, he is a company secretary, he is a cost accountant. He is a law graduate as well as he is a MCOM, having DISA, DIRM and many other qualifications. Apart from this, because he served the chartered accountancy from branch level to apex level of board of governors, the center council of ICAI. He served 6 years in the branch managing committee of the Ghaziabad branch of CIRC of ICAI at various positions. He also served in ICSI at branch level. He also served in ICWI in branch level. After that, taking forward to his journey, at the next stage, he served as a regional council member in the Central India Regional Council and achieved the highest position of the region, the chairman of Central India Regional Council. I think he was the youngest chairman of that council. Then it's the fifth term of C. Anuj Goyal in the Central Council. He served in various committees of ICAI. He is the, I think, senior most in the present council of ICAI. He is the senior most council member, along with one of other colleagues. So fifth term in the Central Council of ICAI and served various capacity, including chairman research committee last year, this year, and then chairman of capital market committee this year and 4 years back also, 5 years back also. So almost each and every department committees he has contributed in the ICAI, and he is encyclopedia about the profession of chartered accountancy. With these words, I take privilege to request CA R.K. Gode sir, the session chairman, for his address and insight about the topic. Over to R.K. Gode sir.
Thanks a lot, Amit ji. Thank you very much for introducing all our members who are present, the distinguished persons. Honorable Chairman of the Research Committee, C. Anuj Goyalji, Central Council member, and Vice Chairman of Research Committee, Sri Pramod Kumar Gupji, who is not present at the moment, again Central Council member, and our learned speaker, Dr. Nigam, who is a Dean of the School of Law, BML Munjal University, and as far as I could gather, he is a legendary resource mind for legal studies. Respected professional colleagues participating in this webinar, ladies and gentlemen, it is indeed a matter of pride and privilege that Research Committee has identified a topic for today's deliberation. That is importance of legal research nurtured in commercial and tax ceremonies. As we are aware that our fraternity of chartered accountants is engaged in the profession of providing services to industry and the government. While trade and industry needs support in analyzing and structuring the transactions, the government needs support for the policy formulation. Whether it is a transaction or policy, it cannot hold without sound legal backing. Therefore, law and business are not mutually exclusive. They cannot be, neither of them can be practiced in isolation. They are rather complementary to each other. An integration of the legal background with other industry sector facilitates the knowledge exchange for mutual benefit. Knowledge sharing amongst the various sectors, including legal sector, benefits all as they are able to embrace the best practices. This is especially true for developing dynamic economies like India, which on one hand witnessing rapid commercial development, but on the other hand must manage the uncertainty concerning the dynamic regulatory environment. In such economies, the legal sector is usually in the state of metamorphosis, which keep on changing and assimilating many things simultaneously to design the changing structure for the transactions and governmental regulations. Similarly, a strong understanding of the business side by a legal person further furnishes the advice given by the legal entities. It is vital to understand that professionals with aptitude of law contribute not only to making business sustainable, but to help them flourish as well. They help them in completing business as well as contractual obligations, commercial transactions, resolving disputes, facilitating flow of funds and investment, encouraging innovation through the protection of intellectual property rights. Because if the invention is there, its protection of the intellectual right is eminent and mandatory. So all these things a person in the practice as a chartered accountant, if he is combined with legal background, then certainly he is be able in a better position to advise their clients. The professionals having technical knowledge of law, blended with their ability to particularly apply legal knowledge, will good enough to determine the online what is legally permissible. And this makes a robust contribution to the range of skills that are needed to augment development of commercial activities. In emerging markets, technological advancement are coupled with regulatory developments usually create a lot of uncertainty in the commercial business. This all may happen if the regular legal research is carried out through the appropriate method with appropriate tool of knowledge. Nigam sir, to my understanding, embracing upon legal research methodology, I personally believe you are the legend, so you may be having enough things. But basically, I believe that the three things are very, very pertinent when we are doing legal research. The writing skills, first, analytical aptitude of a person who is indulging into this practice, and the current knowledge. Because why I am saying the current knowledge? Because the law is ever changing, and it is not replicating in the same fashion. Rather, it is coming out in a very, very different manner. Its interpretation changes quite often in the given set of circumstances. As we call, in हिंदी में कहते हैं देश काल और परिस्थिति, place, time and situation के हिसाब से these keep on changing. So the evaluation of law quite often it is dependent upon the current knowledge and current situation. And lastly, what I wish to emphasize that whatever method or tools are used in the legal research, it must pass the test of jurisprudence, which is a mother womb of the legal processes.
Who is the Dean of the School of Law, B.M. Munjal University, one of the very, very prominent universities of the country, on behalf of the Institute of Chartered Accountants of India, on behalf of the research committee. I acknowledge the presence of Dr. Amit Agarwal and C. Amit Agarwal ji, the pillars of the research committee, and I welcome all our honorable viewers from each and every part of the world. I think more than 3,000 viewers are with us in this webinar. Friends, the Institute of Chartered Accountants of India, which was enacted under the Act of Parliament just after the independence on 1st July 1959. And it was the importance of the and the need of the regulator in the accountancy profession that before our country become democratic, become a republic on 26 January 1950, the parliament of this country thought it fit to have a statutory body under the Act of Parliament in the field of accountancy, the Institute of Chartered Accountants of India. And I'm really very happy to share with Dr. Nigam also that we are trying our level best to see that how we can come up to the expectations of the society. Our ex-president of the country, Dr. APJ Abul Kalam, was of the view that the Chartered Accountants and the Institute of Chartered Accountants of India is the partner in nation building. And through this research committee, we are trying our level best to prove ourselves the real partner in nation building. And in this time of crisis, also the research committee, which is one of the oldest technical committee of the Institute of Chartered Accountants of India, which came into existence in 1955. So the research committee is practically 70 years old technical committee of the Institute of Chartered Accountants of India. And last year, fortunately, I was the chairman of the research committee last year, and last year was the beginning of this pandemic corona. And in spite of this global pandemic, we took a number of initiatives to really prove ourselves that we are real partner in nation building this time of crisis. We tried our level best that we can prove that the Chartered Accountants, the Institute of Chartered Accountants of India, the research committee can really convert this great threat into an opportunity for the nation. We introduced ICAI doctoral scholarship scheme last year, in which the young chartered accountants up to the age of 40 years who are having the inclination towards the research can be handholded by the research committee, by the Institute of Chartered Accountants of India. And the chartered accountants who are having great academic record on 10th and 12th level and want to do the research, want to do the PhD in the field of taxation, commerce, auditing, management, and accounting discipline can come forward. And our very, very high power shortlisting committee will shortlist those candidates from each and every part of the country. And then finally, the research committee will award that scholarship. And only 5 candidates during the whole of the year are supposed to be the eligible candidates for the ICAI doctoral scholarship scheme. And we will pay 50,000 rupees per month for 3 years to 5 scholars who are doing the research on full-time basis. Either they will be sitting in ICAI office, in any of the ICAI office, or they will be sitting with any university, at any university campus. And the last date for submission of the application for the ICAI doctoral scheme is 15th June 2021. I will request all our honorable viewers to see that if we are having young researchers, they can very well come forward and apply for ICAI doctoral scholarship scheme. And we are trying our level best to see that the topics which are good for the profession, which are good for the nation, can be identified so that we can really do something concrete for this great country. Then in the last year itself, in the time of pandemic, we introduced ICAI Research Project Scheme 2020. In this ICAI Research Project Scheme, we will be reimbursing the eligible research projects up to 10 lakh rupees for that research project. And we will not be paying any honorarium. It would be only the reimbursement of the expenditures. And it is open for each and every member of the institute who is having 10 years experience either in practice or in industry. And in addition to that, it is open for the experienced research scholars of a recognized university. I am really very happy to share with the viewers that last year we allotted 7 research projects, Dr. Amit Agarwalji, and all those 7 research projects were completed in the given time frame of 6 months. And 2 of the researchers, if I am not wrong, denied to accept even the reimbursement of the expenditure. This is the commitment of the chartered accountants for the mother institute. This is the commitment of the chartered accountants for the profession, for the nation. And all the topics which we have identified on which the research project was done was good for the profession and in turn was good for the nation. We are trying our level best to see that how the Institute of Chartered Accountants of India, how the members of the Institute of Chartered Accountants of India, in addition to that, all the researchers, whether they are chartered accountants or not, that hardly makes any difference. How we can try to bring them on our platform and can try to use their expertise for the mission of the Prime Minister Modi of the Atmanirbhar Bharat, and how we can really try to take our country towards the objective, toward the target of the 5 trillion economy in the times to come. And one great achievement last year, India is the only country, only IFAC country in which ICAI International Research Award was initiated. Across the globe, only the Institute of Chartered Accountants of India, through its research committee, initiated ICAI International Research Award last year, in which more than 100 nominations were there from each and every part of the world. And we awarded more than 10 countries researchers in this ICAI International Research Award 2020. And this year also, we will be having ICAI International Research Award 2021 at Dubai. The last date for submitting published research papers is 31st May 2021. And the president of the International Federation of Accountants, IFAC, president was the member of the jury last year, and the past president of the IFAC was the jury chairman. So this year we are going to have in Dubai, in which we are having very, very strong presence of the chartered accountants in Gulf countries. We are having around 20,000 chartered accountants who are contributing like anything for the development of the Gulf countries. So we look forward for the nominations for the ICAI International Research Awards, and the last date of the submission is 31st May 2021. Then ICAI Awards for Excellence in Financial Reporting. Just after the research committee came into existence in 1958, we introduced the ICAI Awards for Excellence in Financial Reporting. Last year, we got a maximum number of nominations in the last 7 years. And in spite of the pandemic corona, and I'm quite confident that Dr. Amit Agarwalji, Amit Agarwalji are trying their level best to see that more and more nominations can be there this year, and we expect all-time high, highest number of nominations for ICAI Awards for Excellence in Financial Reporting. Last date of submission of the nomination is 30th September 2021. I will request all our honorable members who are either in industry or in practice to see that how we can have the best of the nominations for the ICAI Awards for Excellence in Financial Reporting. A new category has been added this year for the municipal body, and one category has been deleted this year of the integrated reporting, for which we are having the separate awards this year. Friends, the topic which has been chosen today is very, very important for the profession, for the nation. And ICAI has always dealt with hardships and responded to times of crisis. Every challenging circumstances which presents disorder and fear in the is the best occasion to learn more and fear less. Amidst this chaos caused by the global pandemic COVID-19, the ICAI has come up with several enabling measures and initiatives in order to promote knowledge as the ultimate weapon. The institute has always remained at the technological forefront, and I'm quite confident that the research committee will try its level best to see that in spite of this pandemic, how we can have the knowledge dissemination through webinars with the best of the speakers, either from our country or outside country. And we are having extraordinary response of the membership at large. ICAI has always worked at providing requisite training and equipping its members with the necessary skills and knowledge required to spearhead our country towards economic prosperity. And we are quite confident that with the help of the chartered accountants and the researchers, our country will certainly reach to the target of the 5 trillion economy, and we will do ourselves the superpower in the times to come. In this context, the research committee has come up with this webinar on the importance of legal research methods in commercial and tax advice. Legal research is the process of identifying and retrieving information necessary to support judicial decision making. It involves a holistic inquiry into the values that permeate the law and suggest tasks such as finding primary sources of law or central authority in a given jurisdiction, causes, cases, students, recognition, etc. And I am quite confident that with the delegation of our honorable guest speaker, Dr. Nigam, who is the Dean, School of Open Learning, BM Munjal University, we will certainly be richer in our knowledge. So without taking your further time, may I request Dr. N.S. Nigamji, Dean, School of Law, Munjal University, for his words of wisdom. And after that, we will be taking the queries of the delegates. All the members are requested to please put their queries in our question and answer box. And with this, I once again welcome all our honorable viewers to this very, very important webinar. Over to C.R.K. Gaurji, webinar chair. Thank you very much.
Thanks, Anuj ji. आपने बहुत अच्छी बातें अपनी कमेटी के बारे में बताई हैं, which are not known to most of our members. I'm really grateful to that. And now today we have our learned speaker. Whatever I could search from the websites and Google, I have titled him as a mind of the legal. He's a wonderful person. So I think I don't be here to intervene. I request Nigam sir to please enlighten our members in the context that the boundaries are open, and in international fora, we have to deal with the transactions which are quite often difficult. So with this, I request Ms. Nigam sir to please proceed.
Thank you very much. Thank you very much, Mr. Gaur, Mr. Goyal, Mr. Agarwal, Mr. Paul. It's a pleasure, an absolute pleasure to be here in the midst of very learned and masterful exponents of law and accounting. I am a professor and dean at BM Munjal University, almost at the borderline, still we put it, of law and accounting in some ways, since I teach tax law when I have time to teach. And I've always found it fascinating to listen to and work with the chartered accountant profession because it houses a number of really brilliant scholars who have learned a lot from over the last many years. and therefore I always welcome an opportunity to talk to and interact with people from the accounting profession. I learn a great deal from them. Before I start my presentation, can I just say a word of thanks to Mr. Gao for talking about jurisprudence and knowledge, which in fact, as a happy coincidence, is the topic that I'm going to be talking about today. I will be talking about how jurisprudence or the theory of law is actually at the heart of legal research. And I'll be talking about, as Mr. Gao mentioned, that avenues of knowledge that are dynamic in nature, that change from time to time, are at in some ways critical to legal research today. So I'll be doing that, and thank you, Mr. Gao, very much for actually laying down the groundwork for what I'm going to be talking about today. Similarly, I would like to thank Mr. Goyal as well for his introductory remarks for two reasons. One, that I'm actually elated to see the amount of encouragement that research receives in the profession today. I'm sure through the efforts of Mr. Goyal and his team. And I think that kind of focus on research is necessary in all fields. And accounting, the accounting field has managed it very well in the last few years. And I think what the chartered accounting profession is doing today should be replicated in every other field of inquiry, particularly the legal field, since there is so much more needs to be done to encourage young scholars of this country to actually delve imaginatively and creatively into matters of real importance. So I think it's a great. I congratulate Mr. Goyal for leading these efforts and for all the achievements that have already happened. And I said I want to thank him for two things. The other thing I wanted to thank him for is that he actually gave a gist of legal research, which kind of captures a little bit of what I was going to say and actually serves as a good introduction. He said legal research is the art of excavating, of trying to figure out information in a certain area, and therein lies the heart of the matter. How do we excavate information in a certain domain, in a legal domain? Right? How do we gather the information that we need in order to solve a problem? And that's what I'm going to be talking about in today's talk. So for the roughly an hour and 15 minutes, hour and a half, I'll be talking about the process of legal research that's there in our legal profession, and how that interacts with a lot of issues that chartered accountants actually face on a daily basis. Right? And so I think it'll be really interesting for us, therefore, to discuss what's happening in terms of the controversies in legal research that we face in the law, and how that interacts with anyone who's providing advice on commercial and tax matters. So with that, let me start sharing my screen. And just give me 1 second, please. Sorry.
You shared a screen earlier, but now it is not shared, Dr. Nigam.
Yeah, I'm just trying to figure out what the issue is. Just give me 1 second.
Just 1 minute back, it was shared.
Yeah. Is this?
Yeah.
Can you see it now?
Done.
I think that, yes. Okay. I hope now everyone is able to see the screen. Right?
Yes. Yeah.
Great. So there are two. Let me start by saying that there are many purposes of legal research. Legal research can be used in a variety of circumstances. I will focus on two purposes to begin with, and then I will actually talk about one of the two purposes, which is relevant to our seminar today. The first purpose is, what does the law require in a certain situation? Right? So that's the is question. Right? What is the law? What is the case? And when we say what does the law require in a certain situation, it's not rocket science. It's what every lawyer, every accountant, anybody who advises somebody on a transaction will be talking about. Right? So if you say, for example, what does there's a contract, under contract law, what are the legal rights and responsibilities of parties? We're actually talking about what does the law require in a certain situation. Or if we are talking about tax law and we say, right now, a certain taxpayer, what are his duties, responsibilities under tax law? The question is, what does tax law require in a certain situation? And this is an is question, right? It's talking about what is required. That question is different from what should the law do in a certain situation or what should the law aspire to in a certain situation. Because that question is an ought question. It's a question that is not asking you what is the law on a certain point, but rather it's asking you what should the law be ideally in a certain situation, or what do you think the law ought to be if we wanted a law to help us or to be more efficient. So an easy example in that respect is, let us say, we all are familiar with the IBC, the Insolvency and Bankruptcy Code. It's a flavor of the season. If there are daily issues of controversies regarding the application of the IBC, and one question would be, well, should the IBC be drafted in the way it is drafted, or do we think there should be some difference? Right. So that's one kind of legal research that one ought to be doing. So remember, if you've been looking at the news regarding IBC, there are lots of issues about what do we do with promoters, what do we do with the dues afterwards. Let us say that the company owed tax dues or dues to utilities. What happens once a resolution is achieved? If those dues go away, but there are still some disputes between the utility company and the bankrupt company, or there are some disputes between the tax authorities and the bankrupt company, then what happens after the resolution is done? Not in terms of what is the case, but in terms of how do we draft the IBC, how ought the IBC to be drafted in such a way that it gets rid of these kind of issues, or it solves these issues in the best way possible. Right? So that's an ought question. And whatever we are saying about legal research has to be correlated to the purposes of legal research, right? So it has to be correlated to what, how we find out what the law on a particular point is, or how do we find out how to improve the law or to change the law or to modify the law. So legal research for us has to be able to answer either question number 1 or question number 2. And that's the reason why we are looking at legal research in a particular way. We are saying legal research methods have to achieve this purpose. The purpose of this seminar is to ask yourselves, and all of us, what is the role of legal research in providing advice to a client or in helping a lawyer trying to achieve resolution in the courts or with other clients or with other lawyers. And that question, therefore, pertains more to the first question I asked, which is, what does the law require in a particular situation? And at least on the face of it, this question is a fairly simple question. It's a question of saying, let's look at the legal materials, and then let's find out what the answer is, right? And that looking at the legal materials is the legal research part. And that helps us find out what does the law require in a particular situation. However, that question, which is simple enough on the face of it, is actually a very complicated question. And it is complicated in 2 different ways. It's complicated because, as we shall see later, there is some complexity in it. There is some process to it, which involves a lot of reading, a lot of imagination, a lot of creativity, a lot of thinking. And so it's complicated in that kind of traditional sense of what complication means. It means it's something that can't be done by everyone. It requires some training, it requires some effort, requires some analysis, some hours. But it is also complicated in another sense, which is that it is controversial. Not everyone agrees on what legal research is. Not everyone agrees on what the correct method of legal research is. And in this sense, very interestingly, legal research methods or how to do legal research itself is a question on which there is no unanimity in the legal profession or otherwise. And that makes it, or that adds an additional layer of complexity to the question. Even today, it's not really certain how do we gather the information. Remember, Mr. Gaur in his introductory remarks said legal research is about gathering information and finding out what the information on a particular topic is. And it's not clear even today, how do we gather information? And what is the process of gathering information in order to answer question number one that I put up on the board. Similarly, the reason for this controversy, the reason for this level of complexity we are talking about pertains to what Mr. Gaur said in the beginning, which is that there is a certain jurisprudential controversy at the heart of the matter. And that jurisprudential controversy, that idea of what the law is, the nature of the law, is actually impacting our ideas of what we mean by legal research, right? And so it's one of those interesting areas where the kind of boring, dry, so-called boring, dry areas of legal theory are actually having a very practical impact on how people discuss what the law is on a certain matter. And we'll talk about that quite soon. So that I wanted to just give you this background that legal research can be of two types. And the type that we are talking about is actually controversial even among lawyers. There is no unanimity, there's no kind of certainty about the tools that are used in legal research. Before we go there, though, I want to just talk about some logistics of legal research, which I think is important for anyone talking about this area. Before I go into the heart of the matter, therefore, I would like to spend just a few minutes talking about the mechanics of legal research, which I think is fairly important for anyone in this area. It's particularly important in contemporary times, in the times that we have. Anyone who's familiar with legal research will know, and I'll start from the bottom, will know that there are now legal research e-databases like LexisNexis, Manupatra, SEC Online, where you can go and you can look at case law, you can look at legislation, you can look at regulations, you can look at tribunal decisions, you can look at all the decisions going all the way up to the Supreme Court. You can also look at scholarly articles that are both from domestically and from abroad, which are talking about issues of legal controversies. So, for example, if you're talking about tax law, all of these websites that I've talked about, LexisNexis, Manupatra, SEC Online, all of them have all the tribunal decisions in income tax, all the decisions of the high courts and the Supreme Courts. And in addition to that, they have decisions from the UK courts and also journal articles abroad, published abroad and in India. Right? So in terms of legal information, contemporary, we know that we have all now shifted to e-databases, and we are all familiar with that. So any person who wants to do legal research in this area will have access to one or the other of these legal resources. Certainly all law schools in India have access to it, and most offices which advise clients on legal issues will have access to these resources as well. However, the interesting bit about legal research in India in contemporary times, which is times from day to day, say the last 1 year, last 2 years, these kind of contemporary developments are sometimes hard to track. Right? They're hard to track because the information is dynamic and is changing on an almost daily basis. Mr. Gaur was talking about this. He said, how do we keep track of information that's happening on a daily basis, and they change on a daily basis? IBC is a perfect example, but Companies Act, it goes through the same situation. Our RBI regulations go through the same situation. So you have changes happening almost on a daily basis. How do we keep track of it? And for that, we have resources that were not there in place even 10 years ago. Right? And that's the interesting part of the legal research in India. So we have, many of you will already be familiar with it. We have the PRS, Legislative Research Service, which is, and I've given the website for you, which actually analyzes all central legislation, all federal legislation, as we call it, and it actually analyzes it by summarizing it, by tracking its progress through the legislative development in the two houses, and also then talks about any committee reports that have come up regarding those enactments. There are also several popular blogs that are talk about contemporary statutory developments. I've given an example of the India corporate law blog, but that's just one example. There are actually various blogs that one has to look out for if one is a student of legal research in contemporary times, looking at tracking things that are happening recently. There's also good law firms that have their own research teams, legal research teams, that bring out various essays and papers on recent developments. An example which Mr. Desai associates on tax law, which is my field, especially international tax law. There's lots of information and, in fact, lots of analysis of recent developments. Again, the Nishit Desai website is just an example. There are other websites, Amachan is another example, where there are very good analysis of recent legal research. And of course, there are plenty of really exciting and important work being done by chartered accountants as well, whose work is on the web. I've just given you some examples to indicate that it's important that we, as researchers in contemporary times, where information is being generated very quickly, have to depend on the internet resources and on online services more than textbooks and compilation of case laws, because sometimes they could become a bit outdated with time. The developments are always ahead of scholarship on those developments, and therefore it's important that when we talk about legal research methods in contemporary times, that we keep track of it in an online space, which is, and I've given you some examples of online spaces. We have to be careful though. Online space is full of spurious websites as well, and half-baked information, and therefore one has to be very careful when one scouts the web for information for one's legal research. One has to be very aware of the provenance, the pedigree of the person or the institution that's writing whatever they're writing on any particular topic. I always tell my students that if you're giving me a paper and you're on something which is contemporary, and you're giving me references to a certain website or to a certain institution or to a certain person, please be aware of the pedigree or the provenance of that person or that institution or that website. Right? It's very important for us because there's lots of information out there. Information is not the issue. The issue is the quality of the information. The quantity is no longer a problem in the internet era. It's the quality that's important, and we got to keep track of the quality. Otherwise, we'll be led astray by websites that don't have that kind of information. So now, that was I said I'll talk about the mechanics of legal research before I get into the meat of the topic, and that was my few words on the challenges, advantages, but some pitfalls of legal research in contemporary times. And I want to ensure that this is something that is taken note of. Now, I'll then move on to this question about interpretation, right? I'll come back to that question that I was talking about, right? The question is, what legal rights and duties emerge from the language of a statute? And this question, if you remember, is the question that I said was the first kind of question that is the purpose of legal research. And I have stated this question quite deliberately. So I've said, what legal rights and duties emerge from the language of a statute? Because all of us are dealing with statutes, right? So we're dealing with Income Tax Act or the IBC or the Contract Act or any other piece of commercial legislation, Companies Act. And the question, and all of these legislations, they follow a certain language. And the question is not so much what does the statute say, because that doesn't really give us a flavor of the challenge we are facing. But actually the question is, what legal rights and duties emerge from the language of a statute? And I say that because sometimes a lot of people, including law students, believe that the question, the kind of question I'm asking, is not, in fact, a very controversial question. The question is, well, what does the statute say? We just do what the statute says. But unfortunately, what the statute says doesn't always emerge or does not always clear from the language of the statute. And I'll give you an example. So the example I give my students is the quite popular, famous case of Mahabir Prasad Dwivedi versus State of Uttar Pradesh. And this is a case where a government officer was dismissed by the state government without a hearing. There was an initial hearing by the district magistrate, and then it was that his dismissal was confirmed by the state government. At the stage of confirmation, there was no further hearing given to this officer. And so the officer went to the Supreme Court. The case went all the way to the Supreme Court, and the question was whether is there a right to a fair hearing? Right? Should there be a right to a hearing before before the person's dismissal is confirmed by the Supreme Court, by the state government? And there was no such requirement in the statute. The statute said that a person can be dismissed by the local, in this case, the district magistrate, after a hearing. But after that, the confirmation of that dismissal by the state government the statute did not require another hearing at that stage. The court said that, look here, it doesn't matter if that is the case. It does not matter if the language of the statute is such that it looks like it doesn't require a hearing before confirmation. Natural justice requires that there should be a hearing. So the court said here that in countries with a written constitution, this is, by the way, a judgment by Justice Kharju, it said in countries with a written constitution, however, there is scope for social engineering. So as observed by the Supreme Court, the legislature often fails to keep pace with the changing needs and values, nor is it realistic to expect that it will provide for all contingencies and eventualities. It is therefore not only necessary, but obligatory on the courts to step in to fill the lacuna. So when courts perform this function, undoubtedly they legislate judicially. But that's the kind of legislation which stands implicitly delegated to them to further the object of the legislation and to promote the goals of society, or to put it negatively, to prevent the frustration of the legislation or perversion of the goals and values of society. Hence, in countries like ours, which have a written constitution, we can add or delete words, not only in the situations contemplated by Maxwell and Trace, these are famous authors of statutory interpretation, but also in other situations in order to make the statute more equitable, fair, rational, or democratic. So here's the case where, if you go back to my previous question, which was what legal rights and duties emerge from the language of the statute, the court is saying what emerges from the statute because of the way our statute finds a place in our constitutional scheme. What emerges is, even if it is not the case, even if it is the case that the statute is silent on right to a hearing before dismissal, we can impute that requirement into the statute. So imagine if you're doing legal research and you are being asked to find out what legal duties and rights emerge from the statute. One of the things that complicates your life is that the plain language of the statute is of no assistance to you. The plain language of the statute alone is not going to make a difference. Right? You will have to do something else to the plain language in order to arrive at what you think are the legal rights and duties of the people affected by the statute. Right? And then the question is, well, what is that additional thing that you need to do? Right? And that's that's an interesting but a controversial question. And people don't seem to agree on that. Right? So on that point, then we go to another famous case, and I'm sure all of these cases are cases that are familiar to anyone who has had occasions to give some sort of legal advice or do some sort of legal research or the other. So the other case are two cases. One is ERA versus State, and the other is Macquarie Bank Limited versus Shilpi Cable Technologies. And both these cases are cases in 2017, so they were quite recent cases. And in both cases, Justice Nariman gave some really interesting judgments on statutory interpretation, which are very relevant to legal research and how we find out what to do in a particular, how do we interpret statutes. Right? ERA versus State is a case, the facts of the case were that this was a POCSO case. So this is dealing with child sexual violence. And this, the case dealt with a situation whether this, the POCSO statute applies to someone who has already reached the age of majority, but has the mental capacity of a minor. Right? So the issue was POCSO applies to minors. That's what the statute says. But in this case, the victim in question had passed the age of majority. I think she was almost 37 years old, but she was at a mental age of 8 years old. And the question was whether that makes her a minor for purposes of the POCSO legislation. And in the Macquarie Bank case, the question was in the area of commercial law. The question was, this was the Insolvency and Bankruptcy Code, and the question there was that the Macquarie Bank Limited involved a foreign bank, and the foreign bank had arranged for a default notice to be sent by a non-scheduled bank. That is a bank that is not listed in the IBC. And it had issued a notice by itself. It did not issue a notice to a lawyer. Both of these things were mandatory under the IBC. The IBC requires a notice to be sent by the lawyer of the person who's claiming default, and the IBC requires a default notice, a certificate from a scheduled bank. And the question was, if this thing was not done, then is it a violation of the IBC, or can we overlook those violations? Now, my friends, notice that these are issues of legal research. In a sense, we are trying to figure out what is the law on a particular point. We're trying to figure out what are the legal rights and responsibilities. What are the legal rights of the victim in the IRA case? What are the legal rights of a foreign bank under the IBC in the Macri case? Right? So these are issues of practical importance involving legal research. But at the heart of an answer to this question, what kind of legal research can we do here? What's the product of legal research here? Are actually issues of jurisprudence. How do we read a statute? Right? If the statute is saying that something is mandatory or something is without doubt or question under the statute in the literal sense, how do we read it? How do we understand what that statute is resulting? And in both these cases, Justice Nariman relied on the famous Hayden case to argue for a purposive construction of statutes. So he said, what are the implications of a purposive construction? A purposive construction involves asking what was the law before the enactment, what problems the enactment tries to remedy, and then judge a case in the light of the previous inquiries. My friends, look at how this idea of purposive construction takes place. It involves asking what was the law before the enactment? What, in our case, for example, what was the law on protection of children before the enactment, or what was the law on handling defaults and bankruptcies and insolvencies before the enactment of the IBC? What problems the enactment tries to remedy? And when we say what problems the enactment tries to remedy, we are looking at what economic and social issues were involved that the law was trying to address in that enactment, right? And then judge whatever case comes to in the light of the previous inquiries. Notice how, to borrow words from Mr. Gaur, how holistic this inquiry is, right? So we're looking at not just one victim or one bank. We're looking at actually certain values of efficiency. In the case of IRA, values of child protection, human rights, evidence, civil procedure, and in the case of the Macri Bank Limited, values of good economics, efficiency, defaults, creditor protection, civil procedure, right? So you're talking about the values that are in these kind of enactments that the enactment is now trying to do something about, right? It's a value-based inquiry, right? So research, legal research, which now, when we started legal research, we said legal research, the beginning of legal research is looking at the text of the statute, language of the statute. But now we have gone quite far from the language of the statute, right? We have gone from the language of the statute to an inquiry into a host of economic and social values that are behind the statute. So legal research, therefore, appears to be taking us quite far into areas of social, economic, and even personal issues of ethics and morality that are now important not just as a matter of theoretical inquiry, but actually important in understanding what rights and responsibilities a statute is providing us. Right? And since each part of the enactment is connected to each other, we have to look at the entirety of the enactment. And since the laws are connected to each other, so we will need to look at the entirety of the law beforehand. Right? So it's fascinating for us to see all the different kinds of interconnections and different kinds of roads and crevices into which our inquiry, which was a very simple inquiry to begin with, and then has gone way beyond that and has gone into kind of a roving inquiry, so to speak. So we must see what reading of the enactment, the law before the enactment, helps us find a solution to the case before us. What was the law before the enactment takes into account the law in that area, but the law in that area cannot be understood without doing a Hayden's analysis, which is the purposive analysis we are talking about in that area, which would therefore implicate every other area of law. This is all the more the case when a legislation incorporates several types of procedural and substantive law. To me, that's a very interesting, uh, very interesting aspect of applying the Hayden's analysis. I'll give you an example. In order for Justice Nariman, to talk about the POXO case that I was talking about, and about whether somebody who's past the age of actual physical majority, but actually is has mental age that is less than the age of majority, in order to understand whether that victim will therefore be brought within the POXO legislation, Nariman, in his judgment, Justice Nariman, was looking at constitutional provisions, international provisions, existing legal provisions with respect to the definition of offenses, witness statements, punishments, trial processes, other aspects of POXO, other statutes in pari materia like the Medical Termination of Pregnancy Act, Mental Health Care Act, Rights of Persons with Disabilities Act, National Trust for Autism Act. You can see how this legal research that started as a simple question of what does the age of majority mean in POXO legislation led to a wide variety of inquiries into a number of legislations, each with a different set of ethical and moral values behind it. And that shows you already the depth of legal research required in even answering the simplest of questions in a statute. Now, in Macri, on the other hand, in the IBC case, Justice Nariman had to answer two questions. Was it fatal to the petitioner's case that it did not use a certificate from a financial institution mentioned in the IBC? I mentioned to you how scheduled banks are the ones that are supposed to issue a certificate, and no other bank is allowed to do it. And Macri used a certificate from a non-scheduled institution. And was it fatal to the petitioner's case that the demand notice from the petitioner came from the petitioner's lawyer? In the IBC, it should come from the petitioner itself. That's what the text of the IBC says. And in answering the questions, Justice Nariman adopted a holistic and comprehensive approach to statutory interpretation and said that we are going to look at what the law was before the enactment, what the values and what purposes of this law were, and then answer this question. So in Macri, Justice Nariman said both these questions, even though the text said this is what should happen, the certificate has to come from a financial institution, the demand notice has to come from a petitioner, not from the petitioner's lawyer. Even then, it's okay, we will overlook this. We won't worry about it, because the purpose of the IBC is to ensure that if there's a default, something is done about it. Those are the values of economic efficiency behind the IBC. That's important in the IBC's case, and we should therefore look at IBC from that perspective. So, and also remember that the holistic and comprehensive approach also includes questions of equality and fairness that have constitutional origins. In Justice Kharchu's judgment that I was talking about, it did include questions of equality and fairness. It said, doesn't matter if the statute says that there is no right to hearing before dismissal, we will say, we'll impute the right to hearing before dismissal. So 6 takeaways from these cases. The Hayden case uses a value-based analysis. We look into questions about what values the law finds important to ask, what the law demands of us. Right? So do legislatures ask the same Hayden's kind of question? Well, that's something for you to consider. Also, if it is judges that are asking the moral questions, are they merely applying the intention of the legislatures? It doesn't look like judges are applying the intentions of the actual legislators. What the judges are saying, to me, it looks like from here, what the judges are saying is we look at the values behind the statute, why the statute has been enacted in the way it's been enacted, and then we'll apply the statute, looking at the values. So it's a very value-based inquiry. So at this level, when a person is doing legal research, and they're asking not what the law ought to be. I'm not even on that question, but what the law is. What does the law say? What will the law say to Macri in IBC? What will the law say in actual POXO case? Those questions will depend a lot on a value-based inquiry. And therefore, that legal research will take you into areas of social, economic, and personal ethics and morality, which are absolutely necessary in order for you to answer those kind of questions. So the purposive approach leads to a holistic approach. The purposive approach is also anchored in the text of the statutes and what the courts have decided. And the purposive approach asks us to weigh and harmonize the values together in a particular case. The purposive approach must include the values of fairness and equality founded on constitutional provisions. So you can refer to Justice Kharto's judgment in Dwivedi. Now, one might say that the Hayden inquiry aims at something that's impossible. And in some ways, it is true, right? So whenever I discuss these cases with my students, the first thing I get from my students is, Professor Nigam, I mean, the judge will, if what you say is true, then the judges or anyone giving legal advice will just spend an impossible amount of time trying to figure out what the statute is saying. Because you're saying, in order to figure out one question in the statute, we'll have to look at what the purpose or the values behind the statute are. In order to figure out what the values and purposes behind the statute are, we go into a roving inquiry into all the other related statutes and what the values and purposes behind those statutes are. If we're going to just spend all our time doing it, we'll never be able to give any legal advice to anyone. And there is some truth to the matter. And I think pragmatically, the role of the task of the judge, or indeed the task of anyone who's giving legal advice, is to work pragmatically and progressively to ensure that they can do what they can in the time provided to them. There has to be an end to legal research. One can't be doing only legal research all the time and not give any advice. But we must remember what the legal research is aspiring to. That's what the purpose of this talk is. And it is true that legal research is ambitious in scope, but that is indeed the nature of legal research. So how to read a statute? And what I'm trying to say here is that there's a difference between weighing values, as if on a balance, and weighing values thematically. In the case of the former, the meaning of each value is fixed and one gives way to the other. In the case of the latter, the meaning of each value depends on the other. So to give you an example, the law says freedom of speech cannot be. Let us say there's legislation, in our case, the Constitution, that says the law says freedom of speech cannot be violated, except in the case of security of the state. So security of the state is an exception to the idea that there is freedom of speech in our country. Now, there are two values. Anybody who is kind of interpreting this or applying this legislation or this constitution in this case, there are two values in play in this situation: freedom of expression and state security. One can weigh the two values and say that one value will give way to the other on a weighing scale. But that's not what I'm talking about when I'm talking about legal research. Because this characterization does not require that the values be understood as part of a larger framework or thematic. And I'll tell you what I mean by that. If we approach the same question, thematically, we will strive to find an idea that combines freedom and state security in a certain way. So we have to say, first of all, there are two ideas of a democratic public opinion. So one is an absolutist conception that says that one should engage in free expression of ideas in the face of any countervailing arguments from social security, morality, public order. The other one is a moderate conception that carves out exceptions for social security and morality. So in understanding, in a particular case, let us say the question, let us say a journalist has gotten hold of some state secret, and the journalist wants to release it to the public. The journalist comes to you for advice. and says, look, I've gotten hold of these secrets about our military plans, and I want to make this public because I think the public should know about it. It's a question of legal research here. The journalist is asking you, is it all right for me to do it? How will you answer that journalist? How will any person answer that journalist? What kind of legal research is required here to figure out what the law is on this point? And I'm saying, whether you're a person advising the journalist or you're a judge deciding this question, you will have to go into, in answering this question, which is quite complicated, you'll have to go and take a viewpoint on what you understand by democratic public opinion. You can either have an absolutist conception or you can have a moderate conception. What conception you have of democratic public opinion will then impact what your advice on that particular point would be. So we must ask which conception of a democratic public opinion is more attractive from a moral and ethical point of view, and at the same time fits legal history and context. Now, each of the conceptions we develop will ascribe meaning to freedom of expression and to state security that is linked to their role in the larger framework of maintaining and developing a healthy public opinion. So in order to figure out what the legal rights and responsibilities of a journalist are in a particular situation, one has to go and look at what democracy means and what public opinion in a democracy means. Those are controversial political and ethical ideas that are now impacting on what your sense of a certain constitutional provision or a certain statute is. Right? This makes the whole inquiry potentially exciting, but it also makes that inquiry extraordinarily complicated and controversial. And that's what I'm trying to get at when I'm saying that legal research is by no means an exercise which is free of controversy, which actually legal research inevitably makes you take positions on issues of political and social morality, which not everybody will agree on. Now, let me give you a case from contract law. Right? So this is again a fairly well-known case, Pannalal versus Mohanlal, and it's a case on remoteness of damages. And it's a case, the facts of the case are fairly, I'll simplify it for the purpose of this class, but it's a fairly simple set of facts. There was a principal who asked his commission agent to buy a certain set of materials and put it in and store it in a warehouse. The commission agent bought those materials, but did not insure those materials against any accident or fire. As it so happened, there was a fire. There was an explosion in that warehouse, and because of which the goods were destroyed. Now, the question was whether the commission agent is responsible for the damages, for the fact that those goods were destroyed. And it went to court. Right? The commission agent, the reason this case went to court is because the government then came up with an ordinance which said that if the goods had been insured, the owner of the goods will get full compensation. If the goods were not insured, the owner of the goods will only get half of the compensation. So the facts are there was an explosion. The person who stored the goods did not insure the goods. There was an ordinance or a law passed after that explosion saying that there will be compensation, but the compensation that was given to uninsured goods was less than the compensation that was given to the insured goods. Now, the majority judgment said that the loss of compensation under the ordinance, because the goods were not insured, is a direct result of the agent's failure in insuring the goods. So it appears that the judgment adopted the allocation of risk approach to remoteness of damages. They said, look, in any case of contractual breach, any loss that occurs as a result of the contractual breach has to be allocated between the two contracting parties. Right? Either one contracting party suffers the loss or the other does. This allocation is done on the basis of what is the dominant cause of the loss. So in this case, the dominant cause, the judgment identified the dominant cause, the direct cause of the loss of compensation under the ordinance as the lack of insurance. Therefore, the agents were responsible under the first prong of the famous Hadley versus Baxendale rule, which says that any loss that occurs as a natural consequence of somebody's actions, in this case, somebody's contractual breach, that person who breached is responsible, has to suffer the loss. If we adopt, on the other hand, what we call the assumption of responsibility principle, which has come from some recent UK judgments on remoteness of damages, the famous Mercantile shipping case. If we adopt the assumption of responsibility principle, then the issue is whether the agent had assumed responsibility for the loss arising under the ordinance. Now, one can argue that the agent had assumed responsibility for losses arising from their failure in insuring the goods, but not for a situation where the government did away with the liability question altogether and only gave out half the compensation. I bring this case before you to tell you that there are two ways of looking at remoteness of damages, of the damages question on breach. One is allocation of loss. Any direct loss, anything that's a natural consequence, under the allocation of loss principle, the person whose actions resulted in that direct loss will be responsible. Under the assumption of responsibility principle, it's not any direct loss, but the loss that a party has under the contract assumed responsibility for. Only that loss can be held as something that the party has to remedy. These are two different values. Allocation of loss, depending on direct and natural consequences on one hand, and assumption of responsibility are two different ways of looking at how to hold people accountable for their actions. Right? So how to hold people accountable, which is a moral idea. Right? We hold people accountable for their actions. How to hold people accountable for their actions, there are different perspectives on it. And it depends on which perspective you choose, and of course, which fits the case law well, which will then result in you saying, the outcome of my legal research is that this is what the law on remoteness of damages requires. Now let me come finally to interpretation of tax statutes. Right? So I've given you examples from POCSO, I've given you examples from administrative law, I've given you examples from the IBC, and I've given you examples from Indian contract law on remoteness of damages. And finally, I want to give you, or I want to talk about interpretation of statutes. So I want to give you examples of tax law, right? And tax law has always suffered, it's an exciting area for legal research because when we try to figure out what the law is on a certain point, especially in tax avoidance cases, one always gets into difficulties. Right? So the judicial struggle with interpreting tax statutes emanates from the fact that the judges are uncertain about their ability to consider the intentions of taxpayers in adjudicating on tax-motivated transactions. Now, there are two models of interpretations of tax statutes when it comes to addressing tax planning and avoidance measures. The first model is the limited purposive model. So the partisans of limited purposive interpretation believe that a purposive interpretation helps the court apply the legislation imaginatively to the facts on hand. So when the court is faced with an inquiry into whether a tax statute allows or prohibits a tax benefit, the relevant question to ask is whether the legislature, if it were to be faced with such a situation, can be reasonably thought of as allowing or prohibiting such a tax benefit. Such an inquiry does not limit the judge's inquiry as to the literal meaning of the words of the statute, but instead it enables the judges to look at the statute's impact in a commercial and practical context. So therefore, limited purposive interpretation enables the judges to look into the impact of these words in a commercial rather than a dictionary meaning setting. See, for example, platinum sponge given to employees in lieu of cash can be subject to taxation as if a cash equivalent was provided to employees, even though a literal interpretation of the applicable statute will not allow such an application. However, unless the statute itself has indicated otherwise, a limited purposive interpretation will not look into taxpayer purposes or intentions. A judge using a limited purposive interpretation will not take taxpayer intentions into account because that would take him beyond the authority of the statute. So in filling statutory gaps or resolving ambiguities, the judges do not go beyond the inquiry about what the legislature was supposed to have provided as a matter of guidance, or what the legislature would be taken to have provided as a matter of guidance if it had been appraised of the ambiguities or been aware of the gaps in the laws. So nothing in limited purposive interpretation requires the judges to look into any question extraneous to legislative intention, actual or implied. Now, in contrast with limited purposive interpretation, broad purposive interpretation does not consider the legislation as an authoritative code of conduct that needs to be followed by the judiciary. So broad purposive interpretation considers legislation as purporting to direct the lives of the people who are subject to the politicians that enact the legislation. However, the law that is the outcome of this legislation does not follow as a matter of linguistics from the act of legislation. Instead, the outcome of the legislation is a complex process of reasoning that takes into account several considerations emanating from the best moral justification for the legislation. It is the best moral justification for the legislation that is key, not what the legislature believes or can be taken to believe is the purpose of the legislation. Now, this is crucial for our understanding of legal research. And actually, this is at the heart of the controversy today among lawyers and judges. Because a lot of lawyers and judges believe that what's important is we look at the purpose of the legislation, right? What the intended meaning of the legislators are. Unfortunately, as we have seen here through the analysis of the case law that we have done so far, that's a question that in some ways is impossible to answer. Right? What are the intentions of the legislatures? And actually, it looks to us like that is not the question we should be talking about. What we should be talking about is not so much what the legislators intended, but what is the outcome of the legislation? And what is the outcome of the legislation should not follow, in fact, does not follow, as a matter of linguistics from the act of legislation. Linguistics alone will not help us. We have seen that in the Dwivedi case. So, in Justice Khartu's judgment, as we noticed, it didn't matter if the statute was silent about a right to hearing, so the courts applied it. We noticed in the Macri case that it didn't matter that the IBC said that the certificate of default has to come from a scheduled bank, or that the default notice has to come from the petitioner, not from the petitioner's lawyer. It didn't matter because the judges interpreted it to mean these are all only optional requirements, not mandatory requirements. So our legal research showed that the language or the plain meaning of the statute does not hold us to what we understand the statute to be. Indeed, the outcome of the legislation is a complex process of reasoning that takes into account several considerations emanating from what we believe is the best moral justification legislation. and the best moral justification of the legislation will take us into a very important, crucial, but a very controversial inquiry into the moral and ethical values behind the legislation. And it is the best moral justification for the legislation that is key, not what the legislature believes or can be taken to believe is the purpose of the legislation. So broad purposive interpretation will not be restricted from taking into account taxpayer intentions because it does not purport to bind itself by the language of the statute. What is important is not what the statute is trying to say, but what legal position can best exemplify the purpose of the statute. So broad purposive interpretation will allow a judge to take into account taxpayer intentions in allowing or denying a benefit under a tax treaty if the best justification of a tax statute or a tax treaty encompasses such an inquiry. Now, I do believe Justice Chinnappa Reddy in the McDowell case, which I'm sure all the people attending this webinar are aware of, believed that in a developing country that are short of resources for public welfare, the best justification of tax statutes required that the judiciary deny benefits to what he called as colorable devices. Right? So he said colorable devices cannot be given any credibility. And people said Justice Chinnappa Reddy went beyond the statute. I don't know, they said, what kind of legal research is going on here? And the answer to that question is, what Justice Chinnappa Reddy was doing, in my opinion, was that he was doing a broad purposive interpretation of the statute that looked at all the factors that we look at in understanding what a statute requires, and therefore the best reading of the statute, the best moral reading of any statute, of the statute in that question, the statute was excise sales. The best moral reading of that statute was that colorable devices, by which he meant presumably arrangements that were entered into by the taxpayer primarily in order to avoid taxation, should not be given any credibility. Another prominent example of broad purposive interpretation in the Indian tax domain is the Vodafone case. So all of us are familiar with the Vodafone case. The Vodafone case, companies took advantage of a certain way in which Section 9 was worded, and they said that we know that if India-based capital assets are transferred, they will be subject to taxation, but why don't we therefore transfer non-India-based, foreign-based capital assets? Never mind that those capital assets had their value derived from Indian assets. That doesn't matter. As long as they are foreign assets, they're not situated in India, they should not be subject to Section 9, and therefore not subject to taxation. When it went to the Supreme Court, if you read through the Supreme Court judgment, you notice that the judges in Vodafone could have reiterated the ambit of Section 9. They would have said, look, Section 9 clearly says that only India-situated capital assets are subject to taxation, or are therefore sourced in India, and that there ends the matter. But that's not what the judges did. The judges in Vodafone went beyond that, and they satisfied themselves with an interpretation that went into an elaborate exercise of ascertaining the facts and circumstances of the Hutchinson-Vodafone deal, decided that the transaction, while motivated by tax considerations, was not primarily motivated by tax considerations. The Vodafone decision was premised on the fact that the sale of shares had an overall genuine business purpose behind it, even if some of the steps taken to effectuate the transfer had a tax avoidance purpose. So one might disagree with the judicial characterization of the taxpayer purposes in Vodafone. So one might say, for example, that the purpose here was that was tax avoidance. So one might disagree with that, but that is besides the point, though, which is that the judges did not let the plain wording of the statute prevent them from inquiring into the taxpayer purposes. So they did not prevent that. They said, never mind the plain wording. We are going to look into the holistic analysis of what the capital gains provisions in Section 9 meant, what income tax provisions meant in the context of multinational corporations, how tax law and business law and commercial law and tax planning came together, why taxpayer intentions are important. It's important that taxpayers are not committing any fraud. They have a dominant business objective, but they are then doing tax planning as part of their, or folded within that business objective. And because they're doing something of this sort, we don't think that this is a tax avoidance transaction. So in my opinion, any of this kind of inquiry will inevitably lead to an inquiry of this broad purposive interpretation inquiry that I've been talking about for the past several minutes. So my conclusion here is that legal research involves a holistic inquiry into the values that permeate the law. And so I want to, in my conclusion, I want to talk about these 3 points, which I think, while controversial, are worth taking note of in order for us to understand why legal research has a certain nature or a certain way of dealing with things. One, as I said, legal research involves a holistic inquiry into the values that permeate the law. And I want to focus on both aspects of this statement. One, that it's a holistic inquiry. Any statute on any area of law will ultimately infringe on and will involve many other areas of law. And therefore, it's an inquiry that is not limited to that statute alone. So I gave you an example of the ERA case where POXO was the statute in question, but it implicated various other areas of law, and including procedural and substantive law. I then gave you examples of the Macri case, which is IBC in question, but it implicated all the other, in analyzing what IBC requires and what that particular issue requires in IBC. Anyone who is looking into that will have to look into the design and policy behind the IBC, into the other sections of the IBC, as well as other banking and debt provisions in other areas, including the Companies Act and other allied legislation, and therefore go into a roving inquiry that doesn't involve one legislation or one domain of law only. In addition to that, legal research involves not just a holistic inquiry, but a holistic inquiry into the values that permeate the law. There's no point talking about legal research unless we understand that behind the law, there are certain social and economic values that are important for any student of law to understand. That would mean that a student of law is actually looking into and taking a stand on important questions of ethics and morality. And ethics and morality, sometimes when I talk to people about ethics and morality, they sometimes feel that constitutional law and administrative law are the laws that are most closely associated with ethics and morality. And actually, that's a misleading way of looking at things. Constitutional and administrative law are examples, are good examples of the interplay of ethics and morality, but actually every area of law, whichever area that is, including commercial or tax law, are areas in which one has to necessarily address questions of ethics and morality. I have just given you examples already. The Macri case, talking about the value of what it means to protect creditors, or the Vodafone case, where we're talking about the values behind tax law. What what does it seek to achieve, and what is the dividing line, therefore, between planning, fraud, and avoidance. And these are all questions of in the end, questions ultimately of political morality, and they have to be understood and analyzed, and in any kind of proper legal research, these are the questions that need to be addressed in order to figure out what the taxpayer rights and responsibilities under a tax statute are. So therefore, I say that without a thematic or value-laden exercise, the legal materials that are available to us cannot yield an answer. And this is an important point, again, for anyone who's advising. Clients have to understand that legal materials by themselves, a set of statutes, regulations, case law, they by themselves cannot yield an answer. Right? We have noticed already, I've given you various examples of the plain meaning of the plain text. It doesn't really provide us with an answer. We inevitably will lead to a thematic or a value-laden exercise. And I want to end by saying this is true in all legal research, right? Whether it is considered as easy or hard. Right? And this is the final point that I was trying to make, and I think I need to spend a few minutes on this because this is fairly important. Sometimes when I talk about legal research, and I say that legal research always involves a thematic or a value-laden inquiry, one response I get from people is that appears to us to be either too academic or only applicable to the most extreme complicated cases. The Vodafone case is a very complicated case. Maybe your thematic research, value-laden exercise may apply there in Vodafone case in the Supreme Court, but in our bread and butter cases, where I'm just advising somebody on deductions in tax law, or I'm talking about defaults in IBC, or I'm talking about violations of contract, I don't need to worry about values and themes and all of these kinds. And therefore, the one response to what I'm saying is that the kind of stuff I'm talking about here is applicable to legal research, not generally, but legal research only in certain limited circumstances or in certain limited cases. And my response to that is that again is actually a misleading way of looking at what's happening. What's happening actually in what we think of as easy cases is that in those easy cases, the values in question are not controversial. Right? There's not much of a dispute between us. That's why it makes it a little bit easy. Otherwise, it's not an easy case, right? So, for example, if somebody comes to you and says that, do I drive on the left side of the road or the right side of the road? It's easy for me to say, look, I've done some legal research and the traffic law says you have to drive on the left side of the road. It's easy because all of us agree that in the case of traffic laws, the value of certainty is very important. And therefore, if the text says drive on the left side, there ends the matter. We don't have to worry about it. Right? The left side of the road is where people drive on, end of legal research. But things may not be that simple. Right? Even in the simple case I've given you, you've already made that assumption. You already said that the value of legal certainty means that we all follow one set of rules and we don't worry about any further interpretation. But what if, even in that extremely simple example, what if that day your wife is pregnant and you're driving her to the hospital and you have to drive on the right side of the road because there's no other space available? Things can get easily complicated. And then you start looking into, well, you're violating the law, but what's the value behind the law, behind traffic laws in this case, and therefore are you really violating the law or not? So you can see that the legal research can get quite complicated quite quickly. And the other point is that whatever may be the legal research, whether it's hard or easy, it will always involve value assumptions. Right? The only question is whether those value assumptions are in the background or they come to the foreground. Can I tell you now, it may look very surprising to the audience here, but before the Vodafone case, much before the Vodafone case, a lot of lawyers thought the answer in Section 9 was easy. Right? That India-based capital assets are taxed. If a foreign company shares are being transferred, they will not be taxed. A lot of lawyers thought there was no legal research involved in it. It's an easy answer. Turned out it isn't an easy answer. Right? It went to court. The revenues authorities didn't agree with this interpretation, and it went all the way to the Supreme Court and spent several years being litigated. Right? So so-called easy questions of legal research can become very hard questions of legal research if people disagree. Right? So it's just because people are not disagreeing is the reason why sometimes something looks easy, but it's very easy for an easy question to become really hard. So with that, I will end my my talk. I just wanted to say thank you once again to this CA research body for bringing me here. Thank you very much.
Thank you, Dr. Nigam, for your very, very thought-provoking address on this very, very important topic. I think Dr. Amit Agarwal wants to say something.
Yeah. Thank you, Chairman, sir. Indeed, it was a very, very informative session on legal research. And as a research committee endeavors, I think if with the help of Munjal University, we take some step ahead. And if we think a joint collaboration with Munjal University on doctoral, this ICAI doctoral scheme, under the able guidance of Dr. Nigam, we can explore some opportunities that as far as my knowledge concerned, this Munjal University is having a great infrastructure, and under our doctoral scheme, we can take some scholarship at their institution, and we can have some, because Chairman sir, if you recollect or recall your memories way back in 2000, perhaps it was 2014, 14-15, when we have a seminar on simplification of tax laws, wherein the then leader of opposition and then our former the finance minister Arun Jaitley ji was there, Swami Ramdev ji was there, Dr. Grees Ahuja ji there, Lakhotia ji was there, and we had started a deliberation on how to simplify the tax laws. And I think that deliberation goes on a longer path, and we came out in form of, our country came out in form of a very simplified indirect tax laws in form of GST, one nation, one law. So that way, I think our members, the chartered accountants, having a great insight about tax. We are the person who are dealing day in, day out on various direct and indirect taxes for our clients. We do file returns, we do appeals, we do so with little bit of research, we can suggest some new areas, because it's the theme and core area of the research committee to broaden the tax laws. How we can broaden the tax base of, and so that some hardship should not be there to particular segment, or and how to simplify the tax laws. So this is not only for tax laws, we can think of simplification of other laws also. In my earlier deliberation also in research committee, with your permission, we have decided how to simplify HR laws. Nowadays, I think already central government has taken a step ahead, and three of the act came to simplify. But further, there is a scope of improvement always. So through Institute of Chartered Accountant of India and academics like Munjal University and under the able guidance of Dr. Nigam, we can take up some studies, and jointly we can work out some plan that on concurrent basis, as a partner in nation building, we can proactively suggest government something. This is one area where we can seek from audience views also. Dear viewers, this webinar, my worthy chairman is a visionary chairman, and he believes that it should not be a one-way communication. We believe that through these webinars and VCMs, we reach to the members and other stakeholders by way of giving insight, inviting the experts of the area. At the same time, we believe that we receive suggestion from the members, and through these webinars also, we receive a lot of suggestions from the members, and we implement them. So let me share with you in the ICAI research project scheme also, we have invited suggestions. We have invited proposals. After receiving the proposals, it was the chairman only who thought that it would be proper that if we shortlist some of the proposals, and before awarding these proposals to the researchers, let have a deliberation. First at the research committee level, then in form of webinar and VCMs to public at large, so that we can receive at very first stage, we receive the suggestion that what exactly society wants from that study. It is really very helpful to the researcher also, because researcher with their literature review and other documents, and with their confined ideas, and they prepare a proposal. But if their proposal is shared at initial stage itself, then it is very helpful for them to develop their proposal at initial stage. Then the chairman suggested that in mid-course, before finalizing the report, in mid-course also we should have some webinars. We adopted this last year and we received very good response. We shared the mid-course result with the stakeholders through webinars and VCM. We received suggestion and we did mid-course correction also. Then at the final stage, we shared the results. And I think through this only we could achieve the target. And there is a saying that research is a laboratory research, and it is always it is until unless it is used by the stakeholders, it is no worth. So I think visionary chairman has suggested that each piece of any work should be shared with the stakeholders, so that a concurrent correction can be done or its application can be ensured. Because in that in our 2014, I think we had a seminar in 2014. That time only we spreaded these findings of that seminar. I think this was the reason that at an early stage, this government could have come out with this simplified indirect tax law, GST law. So this is one core area where we can collaborate in form of joint studies, working papers. Sir, let me share with you under the able guidance of the then President, Vice President and Honorable Chair, Vice Chair, Research Committee in 2020, March 2020, if I'm not wrong, in first meeting itself, taken very, very innovative agenda, and it gone through by council and it's what passed. We had a collaborative research scheme under which our institute has taken a step that we can do collaborative research with other universities as well. We have MOU, MRA with various accounting bodies and universities across the globe. But our visionary, the then president and the chairman, was in view that these collaborations should come out in form of a result or some action should be taken on that. Then we initiated collaboration with our MRA institution and the institution of IFAC bodies to have some joint studies. Under this scheme, what we propose that a team from ICAI, and a team from our collaborating institution will join hand. We will decide a mutual interest of topic. Then the expenditure part we will take care as and when required, and our officials as well as our members to whom our research committee deem fit will deploy for that study. And similarly, the other collaborating institute also will join hand with us in form of their technical experts and their infrastructure. And we have a plan to come out some international studies, because if we think only about the scenario of India or some nearby country, then it is not really serving the purpose of global economy or world leader. So I think, Chairman sir, these are two areas where I think we can have some collaboration with the Munjal University and with the members of academia. One more thing I would like to request Dr. Nigam, that sir, I think my colleagues has reached each and every university to popularize our these schemes. Institute do not hesitate to invest some money on some good projects, but at the same time we need quality research. So please do popularize our schemes among our chartered accountants and other academics, professional in academics, those who really want to contribute for the case of nation, for the case of the society. And of course, it should be as per the mandate of ICAI. We cannot fund or invest some money on the topics which are not relevant to our area. But of course, we are very much eager to do some investment on research. Our visionary council has taken this step that yes, of course, institute should be a research-led institution. We do believe in innovations, and we want to be proactive, and we do not hesitate to join hand with other academias, professionals. So I earnestly request you to please, whenever you think that some kind of collaboration can be done with your institution or other institution or an individual, we can explore that opportunities also. Very soon we have received, yesterday I was discussing with my team, we received a proposal that how the meditation, scientific meditation is helping the professional life of our chartered accountants. At the first instance, when I read that proposal, I think it's not as per our mandate. When I go on deeper into the line between the lines of the proposal, I found it is very much relevant, or it's timely to fund or invest such kind of research studies. So I think we are not very rigid on certain areas, but of course it should be somehow connected to the profession of chartered accountancy. And sir, you can, if in your university, if you can allow chartered accountants to do some research in legal areas, because chartered accountants also equally, or I think they are competent enough to pursue any doctorate in, they are eligible for management, they are eligible for commerce, and equally I think they are eligible for, because law is a core subject. They read direct tax, indirect tax, commercial tax, and business law. So I think that area can be explored for chartered accountant. And me or along with my chairman, if time permits, we will visit your institution or some other institution also, and we can have some kind of collaboration. And Chairman sir, you would like to add something?
Yeah, thank you, Amitji. I think we have to conclude at the earliest. Thank you very much. I think we will certainly go ahead and we'll try to do something very, very concrete in association with very prominent university, Munjal University. For Nigam sir, we are having certain questions. Raj Gopal Murli from Chennai. What are the procedures for selecting the research methods in a systematic way kindly discuss by segregating the non-legal ones.
Yeah, so one of the ways in which we have to do that, I think, is a person has to have some appreciation, especially in the context of commercial laws, some appreciation of basic economic and accounting principles. And so that segregation in the context of commercial law is very important. We do that a little bit in law schools already. In our BA or the BBA part of the LLB program, we introduce the students in legal research. In order for them to be good leaders of legal research, we introduce them to basic accounting principles and basic economic principles. So that segregation is very important. Only then will a student appreciate the more complex areas of tax law and commercial law that we've been talking about.
Yeah. And the next query is from Mr. Satyanarayanan from Vadodara. Legal issues on commercial property matter may please be discussed.
Legal issues from what matters, sorry?
Legal issues on commercial property matter may please be discussed.
Well, so I think property law in general, legal research, it is interesting. In fact, the Transfer of Property Act is not, in my opinion, is not taught in law schools in the way it should be taught. It has been in some ways ignored in the law school curriculum. And so when we teach the Transfer of Property Act, we must teach legal research methods that are pertinent to transfer of property, including the very idea of what property is, right? The very idea of what the nature of property is. And when we teach that, I'm glad this question was asked. There are two other allied areas which we need to be taught here. One, the importance of intellectual property. So that's no longer is property dominated by real property or commercial property in a land, in sense of land, but intellectual property as well. So there has to be, one has to learn that in addition to the regular property law principles. And second, one has to have some appreciation of trust law. Trust law is again not taught properly, and it's an important criteria for a good legal researcher in commercial property to know taxation, taxation and other aspects of trusts in order to better appreciate the kind of structures we have in commercial property today, including REITs that are coming to prominence recently.
Yeah. So we have to conclude. It was wonderful deliberation on the importance of legal research methods in commercial and tax advice, and we look forward for the greater deliberation on this topic, as well as the topic of the importance in the legal research. And we are really grateful on behalf of the Institute of Chartered Accountants of India to Dr. Nigam, sir, who is the Dean of School of Open Learning, BM Munjal University, one of the very, very prominent universities of our this part of the NCR, as well as I think one of very, very prominent universities of the country. And we look forward for fruitful association with Dr. Nigam as well as BM Munjal University. We are really grateful to see R.K. God, sir, for chairing this very, very important webinar. And he's contributing like anything for the cause of the profession, for the cause of the members. Thank you very much, sir. And of course, we are really grateful to all our honorable viewers that they are always ready to have the active participation in the initiatives of the Institute of Chartered Accountants of India, in the initiatives of the Research Committee. I think we are trying our level best to have the best of the virtual CP meetings, virtual webinars. And in this time of crisis, Corona, I think how we can update our knowledge, how we can enrich our knowledge, that is very, very important. And I will request all of you to please be at home to the extent possible, be safe, because now this second wave is very, very fatal, and I think it is spreading this pandemic in a more faster manner. I'm really grateful to Dr. Amit Agrawalji, Secretary Research Committee, and CA Amit Agrawalji for their very active contribution, great contribution, 24/7. They are there to see that how we can really do something very, very concrete, not only for the profession, but also for the cause of the nation. So thank you very much, Nigam sir. Thank you very much, Mr. God. Thank you very much, all the viewers. Very, very good evening. Thank you very much.
Thank you to one and all. Thank you. Thank you.
Your guidance is always motivating for all of us. And let me share with you that today the session chairman, the chairman of the committee, the learned speaker, and myself all are law graduates. And
very good.
Sir is heading one institution who has already produced thousands of the law graduates.
Yes, that's. I think he mentioned it, and it's. I'm really happy to be in the company of people who understand on both areas. I think that's really important. And thank you for your points for collaboration. That's something we will definitely talk about whenever we have the next opportunity.
Thank you, sir. Thank you.
That's it. Thank you very much.
Thank you very much.
Very good evening and have a nice day.
Thank you. Thank you.
Thank you.
Thank you.
Thank you, Gosha, for your time and valuable words.
Thank you.